S. Minor Bar Association in Cleveland. I'm Pierce Reed, as you've probably gathered by now, and an attorney at OIP, and I have the very good fortune this evening to be joined by my former colleague and a very dear friend, Lindsay Ford Ellis, which is why I wanted to wait to make sure she could join us. Lindsay is now an attorney working in General Counsel's office at Ohio Health, one of the leaders in healthcare here in Ohio. And she's a longtime leader at JMLBA. But like me, Lindsay's also an alumni of the Chambers of Chief Justice Maureen O'Connor, our featured speaker for tonight, and this very timely and important discussion. But before we get to that, we have to go over a couple of housekeeping items. First, for those of you who are attorneys seeking CLE credit in either Ohio or Kentucky, after this evening's program, you will receive an email with the necessary forms to complete and return to make sure you get credit before your reporting period ends. For you attorneys, not that we don't think you're honest, but we are making sure that attendance is monitored throughout the night so we can comply with the court's requirements for conferring credit on you.
Second, there will be an opportunity for all of you to ask questions to our speaker later this evening. You are free to submit questions through the chat feature you should see on the right side of your screen. You can ask questions and answer later.
And lastly, we just want to welcome two very special guests. Lindsay's very fabulous mother, Wendy Ford, who is joining us from Springfield, Ohio, and my niece, Ursula Avery, who is joining us from Alexandria, Virginia. I know better in my family than to think that Ursula is here because of me. I promise that she is here because of the chief. Those items all said, we want to turn to the presentation tonight, which is entitled Black Robes, Black Lives, the Court's Duty to Understand and Address Systemic Racism. As you know, the last year's been dominated not only by the pandemic and politics, but also by protests throughout the state of Ohio and around the country over the treatment of African Americans, or more accurately, the mistreatment. The fact that we're having a presentation about systemic racism wasn't surprising to people who follow OIP, but the choice of speaker did lead to some questions. And as someone who spent over 12 years working very closely with Chief Justice O'Connor, I sometimes forget that I've seen a side of her that most people don't get to see. And I want to say tonight that she is a person of great integrity. You may not always agree with every one of her decisions, and you may have disagreements with her perceived politics. But you should appreciate not only the fact that she kept me employed for 12 years, but that she is one of the hardest working people I've ever met, and certainly is someone who has always shown me great character and respect. It's something that I learned a long time ago, back in 2004, when the nation's eyes weren't looking at North Carolina or Georgia or Arizona. They were focused right here in Ohio as votes were counted for John Kerry and George Bush. It was also the year that Ohio voters overwhelmingly approved the Defense of Marriage Act constitutional amendment to the Ohio Constitution. And that is what makes it significant that less than a month later, the chief interviewed me for a job. I say that because at the time, my phone wasn't ringing with job offers from other justices. I should point out that I'm a gay man. a Democrat, and I was living in Boston working for an African-American judge who was appointed to the federal court by President Jimmy Carter. So I don't know why the chief interviewed me, but she did, and she offered me the job. What I didn't know at the time was that I became the first openly gay man to serve a justice in Ohio history. And long before the United States Supreme Court ever recognized the rights of me or my family members in a variety of ways, the chief always treated me with the utmost respect and the same equality that she treats everybody to. The fact that the chief is so inclusive and such a proponent of diversity sometimes goes unnoticed. She's hired the most diverse staff of any justice in the Supreme Court. The majority of her attorneys have been women, including the senior judicial attorney that now serves her, Sarah Stafford, who's one of the smartest people I've ever met in my life. And when she became Chief Justice, her first hire of a judicial attorney was an African-American woman.
And I'm proud to say that that little girl was me. When the chief hired me, I was the first African-American to attend the court. But I was a Black woman to join the court that year. Justice Yvette Brown became American, served as a court, having been appointed to Chief's position as a justice. The fact that the chief welcomed Justice McGee Brown made news literally. Major newspapers in Ohio devoted entire articles to the fact that the chief and Justice McGee Brown became friends. And people seemed confused that the chief would welcome a Black Democrat so publicly. But like Pierce said, for those of us who know her, there's nothing confusing about it. The chief not only welcomes people of color, she supports them. She revitalized the court's internship program for law students, expanding opportunities to students at every law school in the state and law schools around the country, including HBCUs. The students became increasingly diverse, and it was generally assumed around the court that if an intern was an African American, Latinx, disabled, LGBTQ, they worked for the chief. The chief has remained a mentor and proponent of mine in the years since I served in her chambers, publicly promoting me and appointing me to boards. She has invested not only in me as an attorney, but me as a woman of color. Pierce and I are proud to call the chief a friend, and in every sense of the word, a leader. She is the kind of leader that the judiciary needs, especially now. To help you understand what Pierce and I already know, we are going to show a short video to focus you on the topic for this evening. Mr. Mims, could you please start the video?
I got a call at about 6:30 on Friday morning from Ryan.
Thursday night, the building was vandalized, as well as some other state buildings downtown, to include the State House.
I was into work about an hour after those calls.
We knew that there were going to be protests, but we had no idea that they would turn to property damage.
Just to see that level of destruction on this court, this building, was shocking, disheartening. But then, of course, it got much worse.
Going into Friday morning, everybody was scrambling to make a plan. What do we do for tonight? Because again, we had intelligence that there was going to be more of that, and just the things that were going on, around the country. We knew that this was going to escalate.
No justice, no peace! No justice, no peace!
Friday night was the worst. Thursday night was kind of an impromptu protest / riot. Friday night, it was more organized. It wasn't uncommon to see vehicles pull behind the crowd and resupply them, if you will, with rocks and frozen water bottles.
Protesters are folks that are exercising their First Amendment right that we would hope that they do. That's what we stand for, right?
When I saw it, I'm not blaming the protesters at all. As disheartened as I was about what happened to our building, I'm equally as disheartened that people in this state feel as disenfranchised, and the treatment that they receive is unfair across all of our institutions. And that's a separate issue, but very disheartening. And, we need to address that. It was the vandals that took advantage of the people who had a legitimate reason to be protesting.
Our facilities team had just sprung into action.
This building is the pinnacle for our judicial system. It's the most beautiful building that Ohio, has.
Just tremendous effort by them, the responsiveness to come in, to acquire at that time. And you can imagine how many buildings had been damaged downtown, particularly glass. So they were one of the first to get on getting plywood and the materials that we would need to secure the building.
My name's Todd Heberly. I work for Berglund Construction, and we just did a 1.5 year restoration project on the Supreme Court, and now we're back to clean up some spray paint. There's about 45 tags like that, and they got some windows, but the spray paint is kind of the worst thing right now because that's just trying to get it out. It's not necessarily getting the paint off, but it's not messing up the stone that's behind it. It's obviously a beautiful building, and you just have to take care on pulling the paint off without etching the stone. So how we're starting is there's a couple different cleaners that we use. One is it's kind of more like a paste, like a jelly, basically, and you put it on, you leave it dwell anywhere from an hour to 24 hours, and that'll kind of eat off. That's more of the thick paint. And then your power washer, we're using a hot power washer that's behind us. It boils the water before it hits the wall. Kind of helps to pull the paint out a little bit.
I think that there's very legitimate concerns, and I think that in many ways I'm learning more and more with each, incident and the triggers to these incidences. No matter how much I learn, I don't know that I'll ever truly appreciate what the feelings are and what the emotions are and the sense of loss and that is built upon centuries of inequality in our country. There's solutions that are going to be proposed. We will embrace those solutions and hopefully, make a tremendous amount of progress here with the entire issues. It's going to take time. It truly is, and I can understand the outrage, and I can understand the voices that say we've given it enough time. It's been our lifetime. It's been our parents' lifetime, and I feel for those people.
Thank you for that amazing video. It is now my pleasure to introduce guest Justice Maureen O'Connor is the 10th Chief Justice of the Supreme Court of Ohio and the first woman to lead the state's judicial branch. Elected twice as a justice and twice as Chief Justice, she has served as a private lawyer, magistrate, common pleas judge, prosecutor, and Ohio Lieutenant Governor and Director of the Department of Public Safety. Chief Justice O'Connor has led many substantial judicial reforms in Ohio and nationally, including a focus on the impact of fines, fees, and bail practices on the poor that led to the substantial rule changes in Ohio in 2020. Her ongoing initiatives include data collection and racial fairness in the court system, conviction reform, expansion of technological innovation in the courts, improved civic education for school children, citizen awareness in judicial elections, and increased funding for civil legal aid efforts. Chief Justice O'Connor also is a regional and national leader on governmental responses to America's drug epidemic. Please welcome our featured speaker this evening, the Chief Justice of the Supreme Court of Ohio, Maureen O'Connor.
Thank you. Thank you, Lindsay. Thank you, Pierce. Thank you for the invitation to be here. I have one question, Pierce. You questioned why I would interview you. My question is why you would want to apply with me. It worked out, though. It really did. We had a great time. And Lindsay, I can't thank you enough for the time you spent in our chambers. And she's right. We've stayed in touch afterwards, and I've watched her career, and I'm very proud of you, Lindsay. So I want to thank you. I want to thank the sponsors here tonight, the Ohio Innocence Project and 3 of the country's premier African American legal organizations, the Black Lawyers Association of Cincinnati, the John Mercer Langston Bar Association, and the Norman S. Minor Bar Association. Now, the work that OIP does is vital, both to identify and remedy wrongful convictions here in Ohio and to give invaluable training to hundreds of law students at the University of Cincinnati, a historic institution that continues a tradition of excellence in training advocates and legal scholars, legal leaders, and addressing some of the most pressing needs in practice and creative, thoughtful scholarship. The work of these 3 bar associations is also noteworthy. BLAC, JMLBA, and the Minor Bar Association provide support, community, and mentoring to African American law students and attorneys, and it is meaningful in the way that they are deserving of recognition and commendation. I'll come back to this point later, but for now, I want to publicly thank you for all that you do. I also want to note that each of these organizations is led by bright, talented, hardworking women. Wednesday Shipp of Procter & Gamble is the president of BLAC. Janae Stevens of Voorhees is the president of JMLBA. And Sierra Colon of Jones Day is the leader of the Minor Bar. With those notes of recognition made, let me say good evening to everyone. It is a pleasure to be here, even if we're here virtually, as we're all used to being virtual these days. I don't know of any other way to meet. Civic duty, public health guidelines, and common sense require that we meet online. The silver lining is that more of you can attend educational events such as these, which are important for us regardless of whether we work, regardless of whatever the work is that we do and where we do it. We have a collective responsibility to be informed about all things, including our health and the health of our government. As I speak to you tonight, I ask you to recognize that systemic racism impacts not only our individual health, but the health of our government and the health of our nation. There is no value in racism. As Justice Thurgood Marshall once explained, and I quote, "Racism separates, but it never liberates. Hatred generates fear, and fear, once given a foothold, blinds, consumes, and imprisons. Nothing is gained from prejudice. No one benefits from racism." Racism is not unlike a horrible virus that spreads through a healthy system. The courts are not immune to racism, but they are uniquely positioned to redress many aspects of systemic racism. The power of the courts is awesome when used properly. In order for the courts to help remove racism from society and to heal the wounds and scars it's left, the judiciary itself must be healthy. In order to be healthy, the judiciary has an obligation to recognize and to understand systemic racism. It is the judicial equivalent to the ancient proverb, physician, heal thyself. The courts and legal professions have much work to do in understanding the way racism, individually and systemically, impact the bench and the bar. So let's start with some basics. The United States Supreme Court was established in 1789. There have been 115 justices to serve on that court. Only 2 have been African American. The Supreme Court of Ohio was founded in 1802. It has 161 justices. It has had 161 justices on the court, and only 4 have been African Americans. In 2018, my colleague, Justice Melody Stewart, became the first African American woman elected to the court. We should celebrate her historic accomplishments, but we cannot be complacent about it. We cannot be complicit in thinking that because one person has succeeded, that's enough. That's enough of a success, because it's not. Equality in our courts will not be accomplished until all people have both equal rights to appear before the court and equal rights to sit on the court. Of course, there is nothing in Ohio law that prevents an African American man or woman from being a justice, but something evidently does so. Justices represent the interest of every Ohioan, including 1.7 million African American Ohioans who make up nearly 15% of our state's population. Yet there are less than 3% of the justices of this state's highest court have been African American. Our judges as a whole do not reflect significant communities of our people. There cannot be more African American judges and justices if there are not more African American law students, or attorneys. And we cannot have more African American attorneys if we don't have more African American law students. For most of the past quarter century, law schools have been decreasing numbers of African American students. In a good year, enrollments are stagnant or slightly increased. The question is, why are there not more African American judges and justices? Why there are not more African American lawyers in Ohio? And why there are not more African American law students in the country? And these are not new questions. At many times they have been answered. The answers to both are both simple and complicated. To paraphrase Professor Taylor at the University of St. Louis College of Law, Black people who aspire to be lawyers are marginalized during law school, admission process, the matriculation process, and the legal employment process. None of this is news to the legal profession. And it is an ongoing, painful reminder that we have a long way to go in ensuring equal opportunity for both law students of color and judges of color. There is cause for some hope, however. We now have many more African American deans of law schools, including the wonderful Verna Williams at OIP's home, the University of Cincinnati College of Law. And I know Verna is on this program this evening, viewing. Hello, Verna. Nice to see you. She is joined by 28 other African American leaders in the nation's 200 plus law schools. Maybe this increase in the diversity of law school leadership will lead to more diversity in admission and enrollment of African American students in law schools. But as we hope for that growth, we also must reflect. The real question is not why there are not more African Americans on the bench and in the bar, but why have we not successfully addressed this clear and obvious disparity? It is a risk to the health of our profession and is a risk to the health of our society. I say that because the legal profession and the courts occupy such a unique place in our society. It is the judiciary that Americans always expect to be fair to all who appear in the courts, regardless of the color, gender, orientation, origin, or wealth of the litigant. It is the courts that are expected to bring clarity, bring order and calm after the chaos of the battles before it. It is the courts that settle the rule of law and guide the people and institutions of society forward productively and peacefully. To be sure, the courts have a mixed history of doing so. Decisions like Dred Scott and Korematsu should haunt all of us as important reminders that no institution is perfect and no institution will always get it right. At the same time, though, we must recognize the power of the courts to get it right, to protect and to promote equality of all Americans, even if it's belated. Decisions like Brown versus the Board of Education are not cliched precedent to be reflected on only during African American History Month, or as a litmus test during Senate confirmation proceedings on the nominees to the United States Supreme Court. They are testaments to the fundamental belief that we are all equal, deserving of the same opportunities in America that our Constitution requires: equality. The Constitution and our laws recognize the importance of equal justice, but it is up to our court systems, to the judges and the lawyers to ensure that the constitutional guarantees are applied equally to all. To ensure that that happens, our elected officials, including our judges, must take inventory of their performance individually and collectively. It is a reality that the judicial system, even though it is the most respected branch of government, has seen the public's level of trust diminish in recent years. As Chief Justice, I'm especially concerned about the low level of trust of the judiciary among African Americans. When asked a few years ago about whether state courts provide equal justice for all, only 32% of African Americans answered in the affirmative. Now, let me explain the importance of that. State courts handle 95 or 96% of all cases that come before a court in this country. The federal system handles at most 5%, and the vast majority of those cases are bankruptcy cases. So it's in the state court system that people find themselves, and only 32% of African Americans answered in the affirmative. When asked if they felt a Black male defendant would experience bias with a white judge, the responses were as followed. 56% of African Americans and 44% of Hispanics felt the African American defendant would suffer bias at the hands of a white judge. Only 30% of whites agreed. This number was still more than 3 times higher than it was for the white defendant appearing before the African American judge. The African American perspective of fairness in treatment cannot be dismissed by the courts as unfounded any more than the African American perspective of police can be dismissed as unfounded. Wrongful convictions illustrate one reason that African Americans may be distrusting of our court system. We know that anyone, regardless of race or gender, can be the victim of a wrongful conviction. If all things were equal, we would expect to see that wrongful convictions appear among racial groups in the same proportion as convictions appear among racial groups. We do not. In the United States, an African American man is 3.5 times more likely to be wrongfully convicted of sexual assault than a white man, 7 times more likely to be wrongfully convicted of murder than a white man, and 12 times more likely to be wrongfully convicted of a drug charge. And nationally, a Black man who is wrongfully convicted of a crime will spend 45% more time in prison before exoneration than a white man who is wrongfully convicted of a crime. Since 1989, Ohio state courts have exonerated 84 people who have been wrongfully convicted, and a federal court in Ohio exonerated 1 other person. In 1989, every person in Ohio that was exonerated was white. And the same thing was true in 1990. But something interesting has happened since then. The trend line over the span of 30 years since 1989 is one that shows more and more African Americans are being exonerated, While the overall percentage of exonerations of white people seems to trend downwards in Ohio cases, the overall percentage of exonerations of Black people trends upwards. Overall, nearly 60% of those 85 Ohioans exonerated since 1989 were African American. When we compare Ohio to the country during the same period, we see that Ohio's rate of exonerations for African Americans is higher than the national percentage, which is 49%. Okay, what do those statistics really tell us? We know that the 60% mark is about 15% higher than the current population of African Americans in Ohio's prisons. So we know that exonerations of African Americans are higher than random probability, but we do not know why. Is it because of a particular type of science like DNA that could establish innocence? Were the exonerations of Black men in a particular type of case? How are the exonerations of Black men different than the exonerations of white men? Those are the kinds of questions that we must answer, not only as we look at how and why wrongful convictions occur, but equally important, we must ask how and why exonerations in wrongful conviction cases occur. And we do so. And as we do so, we cannot simply look at this data and the numbers and the statistics in a void. They have to be put in context. We must remember that every number, every percent symbolizes a human life. One of the most important cases, one of the most important people that I have met is OIP's client, Ricky Jackson. I was so impressed when I met Ricky at Case Law School for an event. I just can't tell you the effect that it had on me. It is truly humbling for someone who has spent a lifetime in public service, including time as a trial court judge and a former prosecutor, to meet someone who was wrongfully convicted in Ohio of a murder that he did not commit. He was sentenced to death and spent nearly 40 years of his life in prison. At the same time, though, it is inspiring to meet someone who shows remarkable strength, grace, and forgiveness in his freedom. The losses that Ricky and every man and woman who is wrongfully convicted, they're unimaginable to the rest of us. To be wrongfully deprived of the love of family and friends, to not be able to join in the milestones of loved ones' lives and deaths is unfathomable. No amount of money, no amount of compensation or judicial order can restore those losses. Ricky suffered, his family suffered, a victim suffered, and the victim's family suffered. Even more tragic is that 2 other men were wrongfully convicted in that same case. Ricky is one example of the value of human life and why all of us, regardless of our professions, regardless of our politics, regardless of all things, should take time to learn how to prevent wrongful convictions. For members of the bench and the bar, it begins with understanding that we are not infallible. Judges do make mistakes, as do prosecutors and defense attorneys and law enforcement officers and jurors. It is exceedingly hard to correct a wrongful conviction after it has occurred. In my time on the Ohio Supreme Court, I have read thousands and thousands of criminal appeals. There are times when any justice may question the verdict in a particular case, but as Ohio's courts of last resort, our constitutional power to review cases is limited. The court cannot accept a case simply because it may have been decided wrongly. It is often said that we accept cases to settle the law, not to settle the facts. As appellate judges, we do not have the opportunity to consider the credibility of witnesses, to understand if identification was accurate or not. We must defer to the work of the trial court judges, and we are often bound by those judges' determinations of who is more credible, even if we might disagree. So every person in the criminal justice system must work diligently to get the decision right the first time. So to do so, judges and lawyers in criminal cases have a duty to understand how wrongful convictions occur. Here in Ohio, we know that some of the leading causes of wrongful convictions include false accusations by members of the community, prosecutorial, police, and government misconduct, erroneous identifications, and inadequate defense. Judges and lawyers must understand these and other causes of wrongful convictions, including implicit and explicit biases against people of color and other members of our community. Judges must also understand the impact that wrongful convictions have on the innocent and their families, the victims and their families, and on every community, including communities of color, that lose faith that true and equal justice occurs in the courts for all people. There are many other ideas worthy of consideration as there is work to be done, but education is one step forward for us. We must move forward with jury, attorney, and judicial education and training programs on implicit bias. We must consider the use registries other than voting records from which to summons potential jurors to ensure a more diverse jury pool and maybe a more diverse understanding of the circumstances of crimes. And we must all understand that we can do better and that we must do better, whether we are prosecutors or public defenders or jurors or judges. Ethical and zealous and fair representation is our duty. Our work in increasing confidence in the courts is not limited to wrongful convictions. Even in cases in which the defendant is guilty of the crime for which he or she is charged, there must be equality in the disposition of those cases, including in sentencing. More than 20 years ago, in the mid-90s, the Ohio Supreme Court established the Ohio Commission on Racial Fairness. The commission was comprised of distinguished members of the courts, the bar, law enforcement, the clergy, academia, and the community. One of the most important of its recommendations, it issued a report, and one of the most important of its recommendations to the justices were those that asked for pretrial and sentencing transparency and accountability in our justice system. Nothing could be more important. The most effective way to increase transparency and to measure perceived discriminatory pretrial and sentencing practices is to collect data regarding race for all criminal and traffic cases, both adult and juvenile. And not only race, all sorts of other data needs to be collected when it comes to involvement within the criminal justice system. And quite frankly, ladies and gentlemen, as most of you know, we do not collect that data. There is not a platform, there's not an aggregate that can be used to use that data and determine what the data shows. And here we are 20 years later, and those recommendations remain unfulfilled. The lack of prioritization, the cost, the complexity has impeded the implementation of the recommendations. And this problem does not rest only with the courts, and it doesn't rest only with Ohio. There's no state in this country that has the comprehensive ability to have a database, an umbrella database for this type of information that we're talking about. So the problem doesn't rest with the courts. It rests with law enforcement, prosecutors, probation officers, corrections officials. All have a lack of actionable and standardized data and the collection methodology that would allow us to be better informed and govern more effectively. I'm embarrassed by this situation. And I have resolved in my last several years on the bench as Chief Justice to do something about it. There's been decades of excuses, and now is the time to act. Businesses, I mean, when you think about it, businesses, the military, medical researchers, even Amazon have all learned to crunch numbers and collect from unwieldy and complicated sources. We now have entire industries built around big data. The judicial system can learn from these successes and act to adapt our collection of vital data about how we impose justice in our state. Best practices demand that data be collected to discern whether the public's thoughts or feelings of mistrust are indeed a reality. Unless the data is there, what we hear is anecdotal And anecdotal does not move the people who are empowered to do something about it. Aggregate data regarding pretrial and sentencing practices in relationship to race, to gender, to ethnic background, or religion does not exist in Ohio on a standardized format. This data gap denies decision makers and the public the necessary information upon which to enact policies and laws. If disparate sentencing based on race is a concern, only data collection will inform us all and help us make fair, equitable decisions in cases, as well as criminal justice policies and laws. Good data also makes form wiser funding decisions that make the most effective use of taxpayer dollars. Data must be used not only formulate policy, but to inform decisions regarding expenditures of public dollars. The amount of money that we expend for prisons, for jails, for law enforcement, for the courts, for the various programs within the court have no measurement to ascertain the value in relationship to the success. And that's something that will be demonstrated once we collect the data. Without data, we are proceeding blindly, and that is contrary to the best interest of the people of Ohio and is contrary to the best interest of justice. It's always been important for this work to occur, but it is even more important now. There's no good reason why we should continue to conduct our criminal justice system behind a curtain of incomplete reporting and incompatible, even haphazard data systems. And today, as we close out one of the most challenging and painful years in history, Americans are looking for reform. If the current unrest in our streets is teaching us anything, it is this. Now is the time to finally come to grips with the racial unfairness that stretches back 400 years. Let's seize on today's sense of urgency. The political will is in the air. Momentum is right now, and it's on the side of justice. I'm determined that we're going to do something about this. As I mentioned, I've got 2 years left on my position as Chief Justice, and then someone else will take over this position. You can therefore understand why this is a priority of mine, but it is a priority that will benefit us all. We will have a unified data system, one connected across all jurisdictions, that will serve as an intelligent and productive umbrella over so many initiatives, including bail reform, pretrial detention, access to justice, fair and impartial treatment at trial, and sentencing reform. Eventually, I envision that it will collect data on arrest and charging decisions, because those are so important in assessing the quality of our system. Data will help ensure faith in our justice system because the public will be better informed and better able to see equal justice for all in action, not in theory. And we must be able to see injustice when it occurs so that we can demand accountability. The way to demonstrate and then monitor equal justice is in facts and figures, in metrics and in transparency. As an equal branch of government, the judiciary does not have to await legislative or executive action to implement a database. The collection of data can be mandated by the Ohio Supreme Court Rules of Superintendents for the courts of Ohio. But we know the Ohio General Assembly is also looking at this issue of data collection and moving forward with proposed legislation that would make meaningful steps forward. One of those proposals is to revise the Criminal Sentencing Commission to become the Criminal Justice Commission with expanded responsibilities, especially for the collection and study of criminal justice data. I trust that the modernization of this commission will receive the urgent attention that it deserves. As we move forward with the database, we must continue our leadership in the reform of other aspects of the system that had disparate impact on African Americans, including how we impose bail before trial and fees and fines upon conviction. I want to also tell you that at this point, there is a pilot project going forward for data collection. I had a meeting before this presentation with you on the data collection initiative that we have. We have a pilot project in Allen County. It's led by Judge Reed. It's partnered with the University of Cincinnati to have sentencing forms and method of conviction forms, and to collect data that is not being collected now. Allen County, Lima, Ohio, is a mid-sized community, a mid-sized court, and it will be a great springboard for what we do going forward. So I speak to you in terms of what we must do, but I want to give you the encouragement for you to know that at this point, we do have a pilot project and we are moving forward on it. This is not just something I'm talking about. This is something that is happening as I speak. Now, getting to bail, advocates for bail reform had convincingly demonstrated that detention based upon the inability to pay can and does have a devastating effect on the poor communities, with disproportionately including communities of color. Loss of jobs, loss of housing, support systems, family stability occur when someone cannot make even the smallest of cash bond. We know, it's documented, that only 3 days of detention, pre-trial detention, can destabilize someone's life. They can lose their job. They can lose their family support. Oftentimes they lose where they live. That the repercussions of that are devastating. And in this time of worsening pandemic numbers, pretrial detention can be a death sentence. We must continue our work at the systemic level to reform bail practices and court-ordered fines and fees in Ohio. In the meantime, however, every trial judge in Ohio can and should incorporate the practice of bail reform in his or her court. Cash bail should be the very last resort, not the first choice. If cash bail is required, it should be set in an amount that the defendant actually has the ability to post. You know, the concept of bail has morphed in this country from what its original intention was. The original purpose of bail was to allow someone to leave detention, to leave jail while their case is proceeding, not to keep them in jail. And it has morphed to the position where people think bail is there to keep someone in jail, and they applaud when a high bail is set or when someone cannot make bail. That is reported in the newspaper almost like it's a good thing. You know, the Constitution demands release without bond unless there is a proven risk of flight or danger to the community, including the victims and the witnesses. If the victims or witnesses are going to be intimidated, are in jeopardy, are in danger, then the defendant needs to be detained pretrial. If there's a great risk of flight, the same thing. But otherwise, there should be means for that individual to be released from jail. Every judge should understand why African Americans have the perspective of the courts that they do. And every judge should work to demonstrate the fair and equal application of the law in his or her courtroom. You know, a judge has control over their own courtroom, as I hear so often from the judiciary. When I think about making sweeping changes, we are independent office holders. Each one of us has been elected independently. And I applaud that. I'm an independent elected official as well. I applaud that. But that empowers you as an elected official to be independent and to be able to incorporate these progressive movements and practices in your court. So I say embrace those, embrace them. As I said, every judge should work to demonstrate the fair and equal application of the law, and that equal application transcends all: the poor and the marginalized, the minority and the majority communities, the young, the old, every gender and sexual identity, the weak and the strong, the citizen and the non-citizen. In short, all who find themselves involved in the justice system. We judges and justices, as individuals and as the embodiment of the institution created to ensure fairness for all, must not let this opportunity to go the way of the past. We must remember the words of Justice Thurgood Marshall, a great jurist, a great lawyer, and a great American. quote, "This is a country which stands tallest in troubled times, a country that clings to fundamental principles, cherishes its constitutional heritage, and rejects simple solutions that compromise the values that lie in the roots of our democratic system." I pray that these words ring true today, even in these horribly painful times. It is up to each of us to fully embrace the principles that Justice Marshall spoke of. We must have faith in our country, faith in our institutions and the courts, faith in ourselves, and faith that we can do better. But beyond faith is the call to action. Action to root out and address racism in our communities and our institutions. And the change must be sustainable. We must, as Ibram X. Kendi wrote in How to Be an Anti-Racist, believe all is not lost for you and me and our society. Believe in the possibility that we can strive to be anti-racist from this day forward. In closing, I chose a quote from a higher authority than the U.S. Supreme Court Justice, from the book of Amos, chapter 8, verses 4 through 7. "Hear this, you who would trample upon the needy and destroy the poor of the land. The Lord has sworn by the pride of Jacob, never will I forget a thing that you've done." Thank you for making this time to join me tonight. And thank you for believing in the possibility that we can work together towards enabling, rebuilding, and continuing the faith in our Ohio courts for all people. Thank you.
Thank you, Chief. I don't know how to do virtual applause, but you would be fitting it if you could. Hands up.
Thank you. Thanks.
As you often do, you've prodded a bit of conversation tonight, but I think you will welcome these questions. The first set goes back to your remarks about the lack of diversity in the legal profession, including both attorneys and judges. And part of the questions have focused on the way the bar examination tends to have a disparate impact on students or applicants of color. Do you think there's a way that we can look at how we administer the bar in such a way that we could be more inclusive, but still make sure that we're testing to make sure that advocates are prepared to represent people? Is that something the court could look at in terms of addressing systemic racism?
Well, interesting that you should say this. This whole COVID thing has brought up an opportunity, for so many things. But one of those opportunities is to re-examine the bar exam. I think many of you may know, if you don't, we had a virtual bar exam this past September. Or no, it was October that they had the bar exam. It was going to be in September, but it was moved to October. And that's the same thing that we're going to do in February, out of necessity. There's some folks that look at that as having the virtual bar exam as being a step forward for people, that it creates a better environment. Someone can take the bar exam in a more comfortable, more conducive atmosphere to their needs. And that is going to be studied. Obviously, Ohio is not the only state that's doing it, but then there's also other states that are incorporating other ways of administering the bar exam. And one of the states, well, maybe more than one, is looking at what is essentially an open book bar exam, which is, I think, fascinating. And I want to, talk to my colleague, the Chief Justice of the states that are doing that, because I want to know what those results are. I want to know what those statistics show. I want to know what, those results show, because, that may be something that we look at. I always say to people, the bar exam, this is my personal opinion, I'm not speaking for the court, is artificial. If you want to give advice to a client based on a half hour of thinking about it and trying to pull up, the right answer for the client based on the situation that they've described to you. That's malpractice, right? That's right. That's malpractice. You can't do that. That's not realistic. And I don't think the bar exam is very realistic. I am in the minority when I, talk like this. And I'm just one vote as on the court, as you know. But I think there's thought. I think that there is movement about reassessing the bar exam and how we do it. And there's a lot of tentacles to that too. The ABA plays a role here in that, and that's that in their oversight and accreditation, that sort of thing. The national, the National Center for Bar Examiners is bar examination. Is another institution that's involved. It's not necessarily a decision that the Supreme Court of Ohio and the 7 justices can make alone. Is something that we need to take a look at. But again, I'm certainly open to it, very much so.
One of the questions that just came in on that topic is why, if someone graduates from an accredited law school in Ohio, they couldn't be admitted to the bar similar to the Wisconsin program. Has that been something the courts looked at?
Yeah, the Wisconsin program is the only one of its like it in the country, is it not? That you graduate from an accredited, I don't know how many law schools they have in Wisconsin. Yeah, we've taken a look at it. That's kind of the diploma privilege that was bandied about, once COVID hit and we were trying to decide what to do. I have to tell you that there was absolutely no appetite with the Bar Association or the justices for a diploma privilege.
Okay.
I'll be honest. I'm just being honest with you.
I told him you were honest. I think you'll appreciate that your proposal for the database is generating a lot of questions. So could you tell us a little bit, one, despite the problems in collecting the data, is there a way that the data can be captured? Is there a role for law schools or law students to play in helping get all of that information, particularly about race and ethnicity, which evidently isn't always reported in each court or jurisdiction? And then the second set of questions, in a way, relates to, once you have the data, assuming that you get it, how is that going to be able to be used? If a particular judge if the data suggests that a particular judge is disparately sentencing with a correlation to race, what happens at that point?
Okay, your first question is there a role for law schools? Well, quite frankly, the sentencing commission, who's orchestrating this data collection project that we're doing, has engaged in a relationship with law school at Ohio State, at Case, and I believe it's Cincinnati as well. I know that we have, those are the 3. I think we might have another one. I can't remember off the top of my head. To put together, so there is a relationship there. But let me explain, when we talk about that data not being available on court documents, okay, it's not, this data collection is going to be much bigger than just collecting court documents. The challenge is to devise, the secret sauce, whatever it is, to be able to permeate other databases where that type of information is being stored and to aggregate it. So, for example, Jobs and Family Services has a lot of demographic data about a lot of people. And a lot of people involved in jobs and family services may also, at some point be involved in the criminal justice system or the Bureau of Motor Vehicles, or, these are all repositories of information around the state, but none of them talk to each other. And they all have, their own data collection. But the goal here is to figure out what data points are necessary to be collected. What do we want? What type of end game is there? Where will this information, where is it stored throughout the state? And how we can access that using technology. And once it's accessed, aggregated, if you will, what do you do with it? And that leads to your second question about who will have access to it, what's it going to be used for? Can a judge, if a judge is demonstrably sentencing people based on race and there's disparity and it can be demonstrated, I think, I'm not going to prejudge anything, but, that's a tool, that transparency is a tool to be used for whatever purpose, given that situation. It'll be used for funding decisions. I would hope that they would look and say, here's the success of this program over the past 5 years. It needs more money because it's such a great program, or maybe it's not a great program and maybe we should look to put our resources someplace else. So that I can see is the legislative's use of a database such as that we will have available. So I would like to see this as being accessible by anybody who wants to do the research. Any academician, any, OIP, if you have a research, interns or personnel have access at it. Because there's going to be, as I said to this group this afternoon before the meeting I had before about the database, we're going to decide access on it, but my push is going to be for open access. It'll be a secure database, make no doubt, no mistake about that, but it will be a database that, as far as I'm concerned, it's a public record. And it can be used and should be used for people who want to take a look at our justice system for whatever their purpose is. You want to know how many blue-eyed men over the height of 6 feet, get convicted. That's just a silly, but I want to be able to figure that out if that was something you'd be interested in. Obviously, much more important things as well. And I want eventually that we will have juvenile data in that as well. I want to see traffic court cases in there as well. I want to see, as I mentioned in my remarks, I want to see arrest practices, and I want to see charging decision data in there as well. Because that's where it all starts, doesn't it? With the charging, the arrest, the charging, you go forward, you've got pretrial. Well, pretrial, is that going to be based on your record? What have you been charged with before? I mean, these are all facts that we don't know. And yet we're making these devastating decisions in people's lives that, in many instances, we are not fully informed, and we need to be.
Chief, we have a few minutes left, and one of the things I wanted to ask you to do is, I noticed that there are a lot of newly elected judges joining us tonight, and I know you will eventually meet them. I don't think their election.
In December, I'm going to be talking to them in December at the new judges training.
Okay, so they've had a good preview. But there are also a lot of students here, both from undergraduate institutions and law schools. As you know, a lot of young people are particularly invested in trying to get things right, and they're frustrated with the rest of us. What can you tell them, especially for students who are so concerned about where we've failed as they continue down their paths to becoming a lawyer or a judge or somebody working in the system, all those other jobs, forensic analysts, journalists, people who play a part in keeping us all honest. What should they take away from a program like tonight?
Well, as an aside, I wish we had more journalists. That's kind of unusual for an elected official to say, but I do wish we did. I miss investigative reporting. There's a lot of shortcomings in our society and our institutions because of the lack of investigative reporting. But I wish we had, and this database would be fabulous resource for anybody that, investigative reporters would be, to have access to something like that for sure. But what do I say to people who are in college and law school and looking forward to a career in, the criminal justice system, the justice system as a whole? See it for what it is, with all of its imperfections and all of its benefits, and seize upon what is productive and what we do well, and be part of the change. This change I'm talking about, my regret is that I didn't start it sooner. But, as I said, the appetite is here now. The motivation is here with the public now. I've tried to start other things in the past and haven't gotten the traction necessary to do it, but I'm getting the traction to do this. Or I have the traction to do this. I have the, authority to do this. And this is something that I think will help inform the people you just mentioned, the students and the people that are coming up in the professions, in the positions that play a role, and for them to question. I think that's one of the most important things that they can do, is question the way things are done and the reason they're done, and pull the curtain aside and look behind it, because that's what we're doing. That's what I'm trying to do. And I'm going to need people to carry on that mission when I'm no longer Chief Justice. So be part of that.
One last thing, Chief. There was a thread of questions talking about diversity on the bench. And as you know, Ohio is one of the states where we elect our judiciary. Mm-hmm. And I've thought about this a lot over the years. I moved here from Massachusetts, where all the judges are appointed. And I've often wondered, what's your sense of which system, an elected judiciary or an appointed judiciary, is best at promoting diversity of all kinds of judicial officers?
Well, it's kind of a moot question for Ohio, because on two separate occasions, 1939 and or 1937 and maybe 1987, 50 years apart anyway, that question was put to the public in the form of, an amendment, constitutional amendment, about changing the election of judges in Ohio to an appointed system. Overwhelmingly, again, in the late 30s, late 80s, overwhelmingly rejected by the voters, saying, no, we want to retain our ability to elect judges in our state. Having said that, there's an overwhelming voter drop-off when it comes to our judges. So people don't vote for judges in the same number that they vote for the governor, the president, or whatever. I think in this last election, there was well over 1 million plus voters that didn't vote for the Supreme Court candidates, compared to voting for the top of the ticket, so to speak. So we're going to have elections in Ohio. That's all there is to it. It's how we conduct those elections. I'm all for nonpartisan elections. I'm all for having people run for election and the two top vote getters run against each other, whether they're two Republicans or two Democrats or one of each, or, whatever, that it shouldn't matter. And then that would be the primary. And then in the general division, the two top vote getters would run in November. I'm also of a mind that all judicial elections should be in the odd years, not the even years. So judges are not competing for the attention of the public against the interest of the presidential or the gubernatorial and all statewide elections, that we do it in what they call the off years, And then judges would be, more prominent on the ballot, more prominent in the news cycle, more prominent with the people who vote, and hopefully they would make more informed decisions that way. They'd have a better interest or bigger interest in the judiciary. This is all part of the package that I proposed, I think, in 2012. Well, here I am talking about it in 2020. What does that tell you? There was absolutely no appetite in the legislature for any of my ideas on judicial reform. But I think that would be one of the answers on how to get people elected who are not reliant on the political process, so to speak. I'd love to see it happen. I'd love to see the experiment put in place and we see what works. Now, I think one of the typical paths for a judge, for someone becoming a judge, is to go through the magistrate system. We have 723 judges in the state of Ohio. We have over 800 magistrates. So judges appoint magistrates. Judges should be appointing magistrates of diversity. That is, we talk about the pipeline. We talk about the pipeline from, high school to college, from college to law school. Let's talk about the pipeline through the magistrate system and see the encouragement of judges making those decisions to employ attorneys of color in magistrates' positions.
Thank you, Chief. That, I think, is going to wrap us up. I want to thank everyone for joining us tonight and putting up with our technical difficulties. I hope you found it worth it. I was joking with Lindsay, we would never try to silence a woman of color at OIP, so that was completely inadvertent. The more voices, the better. I want to make sure that we, particularly at OIP, thank the bar associations. I worked with John Mercer Langston Bar Association for years, and the chief's words are true. It is one of the greatest bar associations in the country. I've been around a few of them, and I'm really happy to be down in Cincinnati where Black is doing a great job, and the Norman S. Minor Bar Association is always a wonderful resource as well. So to our co-sponsors, to all of you, to Lindsay, and especially to Chief Justice Maureen O'Connor, thank you so much for everything tonight. Make sure you take care of yourselves, stay safe, stay sane, and a very happy Thanksgiving to you all.
Bye-bye. Thank you.